I'd like to preface, my job is to present this case and help move the discussion along if necessary. I don't think I'll have to help much. This case, and I'll preface the presentation by saying, in my career, I've done lots of case reports and presentations. And I think this is the hardest one I've ever tried to do. And what do I mean by that? Well, I was involved in the ethics discussions of this case, so I was pretty eminently involved in the initial case 5.5 years ago. And in preparing for this presentation, I went back and looked at the medical records. And as it did when we had the case, it made me physically ill to read day after day after day after day what was happening or not happening. And how do I get that on a PowerPoint without violating the patients and the patients' families' very intimate, dear confidentiality? And I didn't do a good job, because when you see the presentation, it is kind of sterile, kind of generic. And so what I'll try and do is give you a little more than is on the PowerPoint presentation. So let's see. Well, that was wrong. And she said, I've been around a long time.
You hit the Braille button.
Right.
There you go. Push that straight.
Okay. When she said I've been around a long time, I'm an IT idiot. Okay. So, background information. TL was a 14-year-old, previously healthy, very healthy, young man from a northwestern Washington community, not too far from Seattle. He visited his primary care physician one fall afternoon because he got dizzy when he was at football practice. Laboratory studies were done in that doctor's office and were markedly abnormal. And the young man then was referred to Seattle Children's Hospital. By the way, it was a circuitous route because the family was aware of the approach at Children's to blood transfusions. So the boy was first sent to another institution, which immediately referred him to Children's because of the implications of the blood values. Background again, the young man spent the first 10 years of his life with his biologic parents, who were alleged to be chronic substance abusers and subsequently found by the court to be inadequate parents. So when he was 10 years old, he moved to live with his paternal aunt. And this family consisted of 2 female siblings, cousins of the boy, and numerous other very involved relatives. And he loved it. He thrived there. And the aunt was appointed legal guardian with decision capacity. The family, aunt, siblings, friends, family circle were all devout members of Jehovah's Witness faith. Meanwhile, back at Children's, it was determined that the young man had acute high-risk pre-B-cell lymphoblastic leukemia. And the recommended treatment by the HEMOC people there was immediate red blood cell transfusion, since his current RBC level was very low, and I emphasize very low, far below the standard indications for treatment. And also, by the way, multi-agent chemotherapy. So there was a family conference with the patient and his other members of his family. The The diagnosis and the management plan were reviewed. The estimated prognosis communicated to the family with treatment for survival was 70+%, and the estimated prognosis for non-survival with no treatment was nil. So the young man, the aunt, and the others at the bedside, as expected, firmly rejected blood product use. But they enthusiastically supported and wanted the rest of the management plan. So at this point, my colleagues on the HEMOG service asked for an ethics consult. So I think I'm going to stop here and get the other discussants to do their thing, and hopefully all of you all will then form firm, well-based, logical opinions about what should happen, and then I'll come back and finish up.
Well, howdy. Good to see you all. I'm Micah Hester, and I'm very glad to be up here. Frankly, I actually think I beat both Lainey and Norm, but only because I sit in the back every year for the last 8 or 9 years of this conference. I haven't missed a conference yet, so I win there. Ha. Glad to be here. And I've been asked to talk as an ethics consultant, and what I want to do is not try to come up with some pronouncement about the proper, final approach to the case per se, but to give you some idea of how one approaches an ethics case from my standpoint. And there are many different kinds of ethical methodologies out there. And you've seen, even before Paula showed the 4-box method by Johnson, Siegler, Winslade. Wayne Shelton up at Albany Medical College has published a methodology that's kind of based on that and even more robust. Jeffrey Spike has published a methodology he calls Geno's DICE, which is an acronym that leads you all the way from the first call through the chart note. And I use something I call GRACE, which is ironic because I have no religiosity whatsoever, so yeah, so be. I'm going to walk through the GRACE methodology to talk about this and just show you some aspects of how we do this when I think about it and some of my colleagues think about this at my institution. But, let's face it, one of the things about the story is that as we have it, it is a paper story. There's more to it. David could tell us some of that. Marlena will give us some insights as well. But ultimately, we're stuck in a place where we cannot confront and talk carefully with the parents or guardians in this case, the patient, the healthcare providers in real time. And obviously, doing so helps really fill in some of those details. Details that could make a significant difference to how we approach different aspects of this case. So the story, getting the story is first, but it's something we can only do in proxy here. So moving on to the second aspect of GRACE, recognizing obligations. Obligations are replete in the moral life. And they're a central ethical concern in healthcare encounters. And one of the central ethical obligations we have is to try to do what's best for the patients as we confront them. John Lantos, Doug Diekma, and others have pointed out that, in point of fact, where in adult care, we often talk about a primary ethical concern, obligation is to respect patient autonomy, because we start with at least the presumption that patients in pediatrics don't have decisional capacity, we start from a slightly different position, and it turns out that that principle of beneficence really has a kind of primary position in pediatrics in a way that it doesn't quite in adult care. And the reason it doesn't in adult care is because we allow the adults to lead us. This case, however, starts to push on that very question of should the patient be leading us? If this were a 6-week-old, we wouldn't even be confronted with that. But because he's 14, because he has expressed very clearly certain values, we're confronted with what's been come to known as the mature minor doctrine. And the mature minor doctrine could be stated as follows. Any minor who's capable of understanding his or her treatment option is experienced enough to weigh the consequences to him or her of those options, is mature enough to cope with the information, deliberation, and outcomes. Well, that person should have the authority to make the decision at hand. That's what the mature minor doctrine tells us. And even if we accept that the doctrine captures something of value, it captures something of importance, even captures something true about the human condition, we're still confronted with two questions to think about. One's practical in general, and the other's targeted to the case itself. The first question is, even if the mature minor doctrine speaks rightly to moral concerns in human development, are healthcare practitioners capable of determining, with clear, fairly non-contentious reasons and without bias, are healthcare practitioners capable of determining when a patient has such maturity? Now, Lainey Ross has argued that they're not. And in fact, we have no good idea even what we mean by maturity in order to discover it. As such, she's argued that it's better to stick with social consensus on when we're going to recognize that maturity, or at least recognize decisional authority of the individual. That social consensus tends to be, 18 years old, give or take, depending on the laws. But what if we disagree with Lainey? Who would disagree with Lainey? No one. But what if we disagreed with Lainey? We're still left with the second question. Does the patient in this case meet the mature minor doctrine? Doug Diekema, it's funny how they're all here in the audience. Doug Diekema has argued that the neuropsychodevelopmental evidence shows that probably no 14-year-old could meet the mature minor doctrine with regard to life-saving decision-making, at least not in a decisive way. Now, not everyone agrees. It's funny, some of these people aren't here, like Ellen Clayton, Jeffrey Bluestein. They, as scholars, have argued children like this sometimes can meet the mature minor doctrine. We certainly know judges who have, healthcare practitioners, even parents who disagree and believe that some of these patients can meet the mature minor doctrine. But that's all trying to figure out who's positioned to determine what's best in trying to meet our obligation to provide best medical care. But beyond what is best, we're confronted by what Doug has called, following Joel Feinberg, is called the harm principle. It's already been mentioned today. Loretto Kopelman calls avoiding neglect, and even Lainey has talked about in terms of meeting basic needs. This concern is not about achieving aspirational goals about what is best, but instead about meeting our obligations to protect innocent minors from undue harm. If it's the case that allowing a refusal of a blood transfusion for a patient would violate the harm principle, then it would seem that only a recognition that this patient meets the mature minor doctrine could trump that. Because if we recognized that he met the mature minor doctrine, we would treat him as if he is an adult for the purpose of decision-making, and adults have the right to refuse such treatments. So that puts us over into responsibilities and the scope that comes along with certain roles we play. In cases like these, roles determine a great deal regarding the scope of our responsibilities. Parents are responsible for the well-being of their children, for their safety and education. Guardians, in this case, the aunt, is responsible for that as well. But there are limits on what they can do and should do with that responsibility. It's generally agreed that that authority ends when we meet the harm principle, however we define that, even if we debate about that. Now, you'll note in the slide that I start with the role of parents, and then I move to the role of families. And the reason is that Laney in 2009 talked very interestingly about cases where teens and parents actually both agree on a refusal of life-sustaining treatments, and she calls this family refusals. And what's interesting about family refusals is it begins to look like at least courts and some state statutes are starting to recognize the idea that family refusals hold the kind of weight that we give to adult-based refusals, autonomous adult-based refusals, and in a way that they don't give that kind of deference to teen autonomy itself or parental authority by itself. It's only when both of those refusals come together that we're starting to recognize it. So Abraham's Law in Virginia is one of these cases where if a 14-year-old refuses and his or her parents refuse, then they are entitled to refuse and the state is not to step in. So this is an interesting category, and it's a new category to kind of think about. Now, for Laney's money on efficacious treatments, the family refusal doesn't hold enough weight to overdo the fact that this is efficacious treatment of a minor. But it is something to start to think about. Why are courts and state laws doing this? Now, that's parents and families. What about the role and responsibility of healthcare professionals? Healthcare professionals struggle to determine what's the best medical approach to the patient. What are the other reasonable approaches? What approaches cannot hold up to reason? Healthcare practitioners, within the scope of their roles, are charged with providing healthcare, not as acting as police powers of the state. In so doing, healthcare practitioners will confront practical concerns. For example, and David brought this up in one of the phone calls we had together, said, what if we decide to override his refusal? Are we then also going to strap him down so he doesn't pull out the line? These are practical concerns that follow from the kinds of decisions we make and responsibilities we have to think about those practical concerns. Another problem is to recognize that healthcare practitioners carry with them, like all of us, carry with us prejudice and biases. And those biases affect how we look at cases. It affects whether or not we value or disvalue the religious values being expressed in this case. Value or disvalue the role of the minor as a decision maker in this case. And one part of our responsibilities is to be very self-aware of how those biases are playing out. This leaves the role of the state. Should any or all of these kinds of cases be taken to court? Is this the proper venue for these cases? Those kinds of questions are the kinds of questions that healthcare practitioners should think about, because healthcare practitioners are typically the ones who trigger getting the state involved. Now, whether or not the state itself should make certain determinations about this is not as much in our purview, at least not right there at the bedside. We can make our case, but if the state decides to go a different way, there's not usually much we can do. So I come to this slide because this is a case of efficacious treatment, that 70% chance or so of good outcomes through treatment is what this promises. Now, there are other kinds of cases we could talk about, but I'm limiting it to efficacious treatment because in that case, if you look at the final row, you see that family refusal row. And what I find interesting is it seems to be the one row that, short of some other kind of social agreement, either through the courts or the state of some way, it seems like it's the one row that the only option you could pull to treat this child would be to go to court first or to check with the state first before doing so. Otherwise, you're run headlong into something regarding either the parental authority or the mature minor issues. And so I think what that means is we have some real things to think about in the ethics consult, which I'll get to in just 1 minute, after we consider consequences and character. Consequences matter. And there are 3 main consequences, and they're very complex, so it's hard to unpack them all. I won't do them all here by any means. But one is clearly death. One consequence, depending on the path we take, is that the child will die. Another consequence is that if we do provide treatment, that there are burdens from that treatment. And if we do provide treatment, that there may be certain social consequences, personal, psychological consequences to that treatment. His even ability to interact and feel part of that newer family unit that he's part of for the last 4 years can be highly affected by all of that. And of course, there is the question and the consequence of the possible loss of an ultimate good. Marlena will have a lot to say on that in her talk, and so I will leave that to her to spell out. But these kinds of consequences matter, and I find that when I do consults, the reality is that we're particularly uncomfortable when one of the questions at hand is a religious values question, trying to deal with somebody else's differing religious values than our own. If we determine that he is a mature minor, capable of making decisions for himself, well, that leads us one way, and it certainly would make us feel quite, as Ellen Clayton has said, quite disquieted if we preserved his life at the cost of his soul. But if he weren't, it's not entirely clear that the loss is his loss. And the reason I say that is because if we don't think he's a mature minor, he may not own those values at all. So I want to turn lastly to character. It's on my GRACE stuff as evaluate character because I think it is something that resides in the background of many of these cases. It's one of the most challenging parts because it has 3 difficulties at least. We don't know what we mean by it. We end up discussing character in highly speculative ways, and we're in great danger of placing issues like reputation and integrity over the interests of patients. But character matters. Character matters because character is partially about precedent and partially about habit. And those habits are personal and they're institutional. They drive us to look at our values, at how our values are manifest in our behaviors and decisions, how our practices meet our missions. And we need to be willing to justify and own the decisions we make, not only to ourselves, but to others and the larger community in which our practices and institutions reside. So I'll end with this. Now what? Well, as clinical ethicists, we have to think about how we want to present this. When we are confronted with this, we have to think, do we want to approach this through facilitation? Do we want to approach this through mediation? Do we want to offer a recommendation? These are different kinds of practices, and different individual consultants and different institutions have their own approaches. So I will say that I think one thing we need to recognize is if we are called in as ethics committee members or as individual ethicists to a case, we can be well-positioned, maybe even uniquely well-positioned within our institutions to facilitate frank discussions among the various parties. Challenging cases like this are often experienced as adversarial, and ethics facilitation done well can mitigate, even eliminate, the adversarial quality. It can help with better communication among the decision makers and other related persons and start building on shared goals and interests. Now, this is no panacea, and I'm not saying by any means this always solves the problem, but it is something that we need to take advantage of in our role as ethicists, that we can provide a space in which these kinds of conversations can happen, hopefully helping people step back out of the adversarial positions that they often find themselves in. Frankly, in my institution, honestly, most of our consults happen after adversarial positions have already been developed, not before. And so we have work to do to try to break that down. And I think that's really important. So I was asked to just give that overview of what ethicists might think about and a methodology for thinking through it, in my case, the GRACE methodology. I'm going to leave my own position out of this for now. If somebody ever cares to ask me, I have one. But I will leave it out of this, and I will turn the rest over to Marlena.
I need a stool. I need to be taller. So as they said, my name's Marlena Dietzwey. I was raised one of Jehovah's Witnesses, remained one for 40 years, so I'm definitely intimately familiar with the religion. Also in law school, I wrote a paper on the DL case, and I actually appeared before the same judge that ruled on this case and asked him to open the record for me and allow me access to the sealed dependency file so that I could cite. And so he gave me, he affirmed that motion for me, and I do have the ability to cite to these records. So I will be talking about not only internal Jehovah's Witness beliefs and citing to their beliefs, but also I will be citing to the record. So I have a lot to talk about. This is going to come at you kind of like a fire stream, but I have a limited amount of time and a lot of things that I want to say. First off, 2 things I would like you to remember today if you take anything away from this, and that is when you are assessing maturity in a Jehovah's Witness minor, what they're taught and how they internalize these beliefs can give false positives for maturity. Second thing, what happens to them if they have a court-ordered blood transfusion versus what happens to them if they willingly accept blood, because there's 2 different outcomes there. If you are at all interested in this information, I highly recommend you write down the site, the top one that I have there for that paper. Ms. Wood was raised a Jehovah's Witness also. She's a lawyer. Her mother died refusing blood. Her father asked her to bring a medical malpractice case against the hospital because he was certain that if they had just given her EPO, she would have lived. In looking at her dad's claim, she took all the information that the church had given him, because they give a lot of information to their adherents, and she discovered that most of the medical information was just flat garbage. Even though he was committed to it, it was bad medical information. And in this paper, she breaks down what Jehovah's Witnesses are given and why they come in with such strong medical opinions sometimes. And so this raises the question, is it a church or is it a medical provider? And if they're giving medical information, and that's what these patients are basing it off on, sometimes believing their church more than they do their doctors, then can they really adequately assess the risk and benefits of treatment? Some of the things that go through the material that Jehovah's Witnesses are provided is that you have a really high risk of contracting a disease if you accept blood. You guys are making recommendations just in the dark. You really don't know what you're talking about when you recommend blood. EPO is a panacea, that and some volume expanders, and everything's going to be fine. So again, is it a church or is it a medical provider? Not only do they provide skewed medical advice, but the universe is limited for Jehovah's Witnesses. You are not allowed to look outside church materials for information. This is a quote here from the September 2007 Kingdom Ministry. You'll love the title of this article. Does the faithful and discreet slave, and that's code word for church leadership, endorse independent study groups of witnesses who meet together to engage in spiritual research or debate? Short answer was no. If you're a Jehovah's Witness and the church says black is white, you believe black is white, and you don't get together to discuss that even amongst yourselves. And also, you don't access information from any websites literature, anything that is not church approved. So again, this is the quantum and quality of information that this young man would have had when he was making his decisions here. So now I want to drill down into some specifics of the actual case. The Bioethics Conference, November 9th, recommended blood transfusion. Again, beneficence, overruled, but they did say they wanted to show respect and hold off as long as possible. So on November 20th, his attending physician set an absolute deadline for transfusion, said the next day she was going to transfuse, and told the aunt that she could seek a court injunction if she wanted to. The 21st comes along, no transfusion. Instead, a DNR was placed in his EMR. So what happened in between? Child Protective Services supervisor note, November 26th, shows some insight into this. It appears the attending physician told Child Protective Services that he consulted with 5 other oncologists and that they unanimously agreed that coercing treatment is wrong and that someone who's over 14 should be able to make these types of decisions. Later on in oral testimony, he clarified lack of coercion and capacity. But again, you have to ask, is that really the legal standard in Washington state? Because the judge did not think so. When the attorney for the young man was speaking and going off on his First Amendment argument, the judge flat interrupted him and said, he's not 18, he can't consent. How do you get around this? And there never really was an answer to that. Yes, we do have the mature minor doctrine. It has never been adopted in Washington state. Instead, we basically just work through the informed consent process. So looking at this case, informed consent, I want to now transfer into some specific things that the church teaches. When a Jehovah's Witness client walks through the door, they have been pre-programmed for litigation. The church has a script that they give, and parents are encouraged to have practice sessions with their children and pepper them with these questions so that they can respond to judges and doctors. This is a quote here from basically the one that gives the rule that you're supposed to have the practice sessions with them. This next quote is from the 1990 Kingdom Ministry, pages 3 through 6. Are you ready to face a faith-challenging medical situation? On the top is the aunt's oral testimony. On the bottom is the script, and you can see how similar they are. The script bases, actually reverse that. Script's on top, aunt's on the bottom. The script says, I want to live, I don't want my child to die. And for parents, you're supposed to say, I could have stayed home. I didn't need to come here and seek treatment. And that's exactly what the aunt said. She kind of split it between making some of them DL statements and some of them hers. But you can see how very, very close to the script she's following this. I'm not going to go through the whole script. These are a couple of other examples. Don't tell the doctor, judge, or administrator that you're willing to let your child die. They'll think you want to sacrifice your child. It's okay to do that, just don't tell them. Don't tell them about the resurrection hope. They'll think you're a fanatic. This is the most disturbing part of the script, though, and that is claiming that a forced blood transfusion is equal to rape. And you will find that claim ubiquitous throughout all these Jehovah's Witness mature minor cases. DL also made threats of physical resistance. Now, originally, the bioethics committee said, he's just really passive about this. No, we're going to transfuse. And then apparently throughout his tenure, he started pushing back more on physical resistance. But you have to ask, why did he not bring up physical resistance in the beginning? Was he just starting to go along with the script? Because of threats of physical resistance, the attending physician did ask for the permission to restrain if the judge granted the blood transfusion. And also the hospital social worker testified that DL said that he would do anything within his power to resist blood transfusions. It impacted the judge. It was actually part of his decision. He referenced that. One of Dennis's teachers, I believe it was like a 6th grade teacher, testified also. She said she was not surprised that he threatened physical resistance, that she saw him as this little boy who was abandoned by his parents and who's now being asked to do something that might harm his relationship with his God, and he would lose that also, and that he just really needed the attention of adults around him. But in looking at it from the provider's perspective, you really can't at least I don't, blame the decision-making of the hospital at the time, because if you were faced with a young man like this who is making claims of physical resistance, who can quote some scripture, he can talk about EPO, he appears to have some medical knowledge, you're probably going to think that this is really a mature minor. And so it was totally reasonable, stepping back from my own biases, looking at their position to probably make the decision that they made. So I do not blame them one bit for that. However, there are some big issues that we need to look at, and one of them actually came up this week. There's a brand new case that came out of Wisconsin, the case of Sheila W., and she's a 15-year-old Jehovah's Witness that they did transfuse on through court order. But one of the things that the judge mentions in his, actually it's a concurrence that came out, he says that some Jehovah's Witnesses have been accused of disfellowshipping, even shunning members who consent to blood transfusions, and that if this is true, though they didn't have the briefing to rule on it, the existence of these accusations inevitably raises questions of coercion. And I can assure you this is not a possibility of disfellowshipping or shunning. It's a church policy. The bottom quote is from the Director of Clinical Affairs for Jehovah's Witnesses in Canada. He is over all their hospital information services there. And as he says succinctly, if you accept blood, the church is going to view you as terminating your relationship with them. Now, he nuances it between termination versus being kicked out. So are you fired or did you quit? Either way, it's the same end result. The person is shunned. And shunning is the literal translation of 2 John 1:10. You don't say a greeting. You're invisible. You're not looked at. You're not spoken to. You don't exist. Looking at this minor, it's reasonable to believe that he truly had these religious beliefs. And if that is the case, then he was in a Hobson's choice, where he died either way. If he accepted blood, he would save his present life, but he would lose his afterlife, and he would be disfellowshipped, which is excommunication with shunning. If he refused blood, he would lose his present life, but he's guaranteed of an afterlife. But either way, there's death. And so we really put him in this position of having to, if he wanted to live, give up that safe environment that he had just recently found, that he'd only had for 48 months, to lose all his friends and family at the Kingdom Hall, where he attends church services, to be invisible when he finally found warmth and love. And that was the choice that he faced if he wanted to live. So the Wisconsin judge is correct. If you have a Jehovah's Witness, there's a coercion issue there. Interestingly, when the aunt testified, she told the judge that he would not face any consequences within the church, that the church would just, he wouldn't be judged at all by the community. The judge repeatedly asked about coercion. It was a very, very key issue for him. And both the attending physician and the hospital social worker said that they did not feel he was being coerced. In basically the informed consent meeting that the attending physician had with him, he asked him, do you feel that you're being coerced? And he said no, but it's really doubtful that a minor is just going to say, oh, yeah, I'm being coerced. So I don't know that we can really use that as evidence. But again, the judge repeatedly asked about this. And I believe the other thing that was interesting is that the aunt did confirm, as did the young man's attorney, that if he had a blood transfusion, that there would be some issues as to what would happen within the church. So that's what the judge was trying to balance out. He's getting conflicting information here. You have the aunt saying, no, there's nothing, but then you have other information showing that, yes, there would be something. Bottom line is, I think if anyone had told the judge, yeah, he's going to face some consequences, or there's possible consequences, I think this decision would have come out much differently. I think perhaps the hospital social worker or the attending physician, though they might have felt that he personally didn't face coercion, that it was an issue that you all are familiar with as practitioners. You know Jehovah's Witnesses' beliefs. I go on PubMed. I've seen what's been written about them out there. And I think that should have been brought up to the judge so that he could have made that decision and at least been aware of it. But if he had been made aware of it and he did make the decision to transfuse, what would have happened to the minor. A court-ordered blood transfusion is a get-out-of-jail-free card, literally. It takes him totally out of this decisional conundrum. He would have been able to live now, and he would have his hope of afterlife. There is no losing your soul if you have a court-ordered blood transfusion. The quote that I have there is from the Watchtower, August 15th, 67, page 511. Basically, the court bears the responsibility for what it does if it orders a blood transfusion. The minor's aunt and his lawyer did admit to the judge that if there were any consequences, that would have been shifted to the court. So that leaves us then with issues of uncleanness, possible psychological harm. That I really can't address. That would be on an individual basis. The only thing I could say is that really a sufficient justification to allow them to die? If you had a young woman who came in and she'd been raped and she was feeling unclean, would we say, wow, you're an autonomous person. Let me help you out here. I'm not going to interfere. I'm not going to do anything. I respect your autonomy. I don't know that we would do that. And so that's just an individual decision. I have my own decisions on that, but that's for each person to make. Again, 2 issues I would like for all of you to take away from this today, and that is false positives for maturity. When someone comes in that primed for litigation, and primed on how to respond to hospital authorities and judicial authorities, you have to ask, really, is what you're getting their true feedback, or is this the training that has happened to them? Second issue, get out of jail free card. If you don't know, if you do transfuse, if you seek a court order, then that child will not face repercussions within the church. That blame is shifted to the judicial officials who enact it. So I thank you for your time.
So, you don't get to be an emeritus by not being able to look at a case in retrospect and come up with all these pearls of wisdom and critical analysis and wisdom. But I'm stymied. I've been back over this case numerous times, most recently in preparation for this conference a couple weeks ago, and I went and interviewed the 2 different hematology attendings who were involved, and they're stymied. And when one says to them, what would you do different? They're not quite sure. So I'm struggling to come up with a take-home message here for you all. So let's finish up. There was an ethics consult, and as might have been predicted, the consult indicated that there was a lot of difficulty in determining whether or not the boy was able to make his own decisions, had competence. But I can tell you, I sat with him, both with the family and the aunt, and by myself with him. And he was pretty impressive. He knew your party line pretty well. So the compromise plan was to start chemotherapy and intravenous iron and erythropoietin as throw-ins to try and stimulate this marrow that was not only being suppressed by the disease, but by the treatment, which, by the way, was a major issue for the hematologist, a moral issue for them. And they minimized blood studies, and for the time being, they held off on blood transfusions. And we're talking here about a hematocrit that's between single and double digits, okay? We're also talking about this kid, football player, who was big physically and who was very articulate. He looked you in the eye, his body language was impressive, etc. And the hematologist went by every day, and in their notes, they documented his physical deterioration. The trigger point was when he began to show congestive heart failure, they would transfuse him. And that was repeated every day in the notes. And they talked to him every day, and they would say at the end of their canned physical examination and daily note, 20 minutes spent with a patient, 30 minutes spent with a patient discussing the important issues. As I said, there were daily extensive bedside discussions. But after about 7 or 8 days, it became impossible for them to morally continue with a treatment plan. And after all of these discussions, and again, some of them one-to-one with the boy and with the family not there, the hematologists, attendings, the house staff, the hematology fellows, the nursing staff, and everybody who was involved reached the point where they thought changing the treatment plan to comfort care was appropriate. And of course, the young man and his aunt endorsed this plan. So at this point, someone in the hierarchy of the hospital thought, well, there should be a CPS referral. And it worked its way up the CPS chain of command and ultimately came before the court. I think, and I'm willing to be challenged on this, 4 days or so after the initial referral. How's that for quick response? The case was referred to a county judge in the county of origin, and after interviewing the attending physician and the social worker, the aunt, et cetera, the judge ruled that comfort care approach should proceed. And fortunately, the court met that afternoon because the young man died that night. So, as I said, I'm not sure what to take away from this. I've transfused lots of Jehovah's Witness children, but most of them were babies because I'm a neonatologist. It always stressed me and made me have moral concerns about my approach, but I did it. And it was easy mechanically to do it. And as Marlena said, the family, after the event, went along. And I couldn't say that I ever saw any evidence of rejection or whatever. But in my daily, or not daily, frequent conversations with the HEMOC attendings, they did bring up the fact that they had this discussion with the young man as to whether or not they were just going to come and do it. And he did indeed say to them he would fight them and pull the line out and resist them with every ounce of strength he had. And, well, the response to that is, well, give it a shot, right? What does it hurt? And I said, well, why didn't you do that? And the one attending said, okay, so I write the order. That means a nurse has to bring the bag of blood in the room, get out the stuff to start the IV, and if he resists, what is she going to call security? How far do you push it? So it's there's the ethical side of this, the ethical moral side of this, and there's the practical side. And I think those daily discussions between the providers and the young man convinced them that he meant it and that they would be wrong to push it. So is the end result here right or is it wrong? Thank you very much. Does anybody have? So we have 5 minutes for comments or questions. Goodness gracious.
Goes on. Hi.
I knew I could count on you.
Hi, David, and thanks, Micah and Marlena. My question is really to you, Marlena, about your comment of trying to distinguish between church teaching and the adolescent's actual religious beliefs. And you seem to make a distinction there that I'm trying to get my head around because practically I'm not sure how, as a practitioner, I'd be able to separate those two things out as distinct. But then I thought even more generally, in any religion, really, there are teachings that we who adhere to those, to that religion sort of believe. And I'm not sure I myself, for instance, as a Roman Catholic, can distinguish my own beliefs in Catholicism from what you call religious teachings, and whether that's a really clinically and morally important distinction to make. And if you could comment more on that.
So if I'm understanding your question, you're asking, can you ever really distinguish if it's their belief, if it's their true belief, or if it's just taught? Is there a distinction between the two? Because we all teach our children religion, correct? Is that
Right.
Okay, I get what you're saying. And actually, I had an interesting conversation with a Roman Catholic attorney at Pierce County Civil Division, because I did a whole year-long internship there, and we were discussing this case because I was very concerned that I was just so, biased that it would be really hard for me to step back. And after so I reviewed the case the paper that I wrote with probably about 5 different attorneys, and one of the things she mentioned is she said, I'm a very devout Roman Catholic, and she's got 2 teenage sons. And she said, every day when we watch the news, I train them on how to distinguish fact from fiction and to be really critical thinkers. And with all of that, my kids believe their beliefs because I taught them that. And so I think that's the distinction that I'm trying to make, is in Jehovah's Witness world, you're not allowed to think. Even if you're an adult, you're not allowed to challenge beliefs. And so there is a difference, I do believe, between a Jehovah's Witness minor that comes in with that level of coercive environment in its learning, and a generic young person who, has the benefit of a family who's allowing them to think and make decisions on their own. I think that attorney's young child in the same situation really might be a mature minor, because he knows and he has critical thinking skills, and he works through that. If they come in primed for litigation, if they're not allowed to think, if they're not allowed to access material, then I don't know how they can understand the risks and benefits of treatment, and I don't know how that you could say that they're not being coerced.
That's helpful, and I'll just end with one other question. What is faith?
What is faith?
Excuse me. My name's Greg Manship, and I happen to be an ordained pastor, and I'm a scholar in Hebrew and Greek. And just, first of all, a comment. And I have to tell you how distressing this is. To know that, and it's not just Jehovah's Witnesses, but it's others who will take the ancient languages and without any background, with no studying whatsoever, but will embrace a particular English translation and say, this is how God spoke, which continues to amaze me that God spoke the King's English. And only the King of 1611, which further troubles me. But, so my comment is just how distressing it is as a pastor, as a clinical ethics consultant, as someone who watches this happen and know that the first thing that I want to do is literally to grab them and say, this is the word, this is the Hebrew, this is what it reads, this is what it's meant in its context, or this is the Greek, and this is what John meant when he wrote this and said, don't greet these people, but it was for a totally different reason. And so I just make that comment because I don't know if that's a frustration that's being felt by others at this time or not, but there's empathy there. Second, I have a question, and it is with regards to not just Jehovah's Witnesses, but others. Is there any legitimacy, any validity whatsoever to have at the consultants or at the ethics committee's beck and call someone who has this kind of scholarly experience with hermeneutics, with interpretation, who can be called upon as a consultant to come in and to talk, and perhaps to have those who are used to be or still in a tradition but have a contrary view, and bring them in to have this conversation with the family, with the patient, to say, look, it's not just the magisterium. It's not just, and I don't mean that in a derogatory sense, but it's not just the magisterium. It's not just the bishopric. It is a tradition, and the tradition has different ways of looking at this. You need to understand the tradition. Is that plausible? Is that feasible? And thank you for listening.
Thank you. Jan?
Hold on, I gotta ask,
Respond.
what are we trying to accomplish if we did that? I mean, are we trying to accomplish to convince them that they're wrong? If we're already on that position, then let's just go ahead and transfuse and get it over with. I mean, it seems like an awful lot of work to go through, especially since chances are you're not going to convince them. I'm just trying to figure out what we accomplish when we do that. I'm not entirely opposed to it. I'm not sure what we get.
I would think for Jehovah's Witnesses it would harden their position because they're taught that. It would have hardened my position when I was a Jehovah's Witness. I would have been, I'm just being persecuted. They're bringing these people in and challenging my beliefs. They're attacking my religious faith. That's how I would have interpreted it. They're given a lot of information on bad motive that's impugned to medical staff. And I would have just looked at that and said, well, there you go, just like the church says. They're just trying to get me to break my faith. That's what they're trying to do. So again, if you're dealing with someone who's got critical thinking skills and they're looking in, yeah, I want some information. I want to know, I want to make the best decision here. Give me all you've got, then that will work. However, you might want to look at a website, AJWRB. There's a lot of internal conflict in the church. It's not still a well-received dogma. And this website is by a group of men who were hospital liaison committee members. And some of them are still active. Some of them are still elders, and some of them still are on the HLC, but they have to be underground because they would be disfellowshipped. And they actually have a whole website where they work through all this stuff and have information for Jehovah's Witnesses. That website was critical in me leaving because it went through some of the critical.
Let's move on, Jen.
The question came up a couple of times about whether or not this young man was subject to coercion based on some kind of religious indoctrination. But I guess my question is, are young teenagers, even outside of religious communities, ever really able to be free of coercion in that they depend on their parents for food and shelter and money and all kinds of basic needs? So my question is, are young teenagers ever really free of coercion from their families?
Probably not. I'm not talking to all teenagers. I'm talking to about Jehovah's Witness teenagers. That's what I know. That's the information I'm presenting. As I said earlier, I think some other teenagers might be mature minors. I think that is a valid legal doctrine that we can employ. I think if you're pre-training children for pre-litigation speech, I think you've crossed the line from training into coercion. I can give you one example. One of the last meetings that I attended, one of the elders in the congregation had 6 8-year-old sons, and they were talking about having one of the practice sessions because about every year or so, there's an official meeting on the blood issue. And at that meeting, the elder proudly told about practicing with his kids, holding them down on the ground and having them scream and kick, "No blood." So again, where is parenting versus where does that line end? I can't tell you. That's a decision that you're going to have to make. So what's parenting, what's coercion? Is all parenting coercion? Maybe. all I know is Jehovah's Witnesses, and that's what I'm speaking to.
Ross?
This is a really quick question for Ms. Deesway, but I think one of the aspects of this case that we didn't talk about is that this wasn't transfusion for a hemorrhage. I mean, this was the beginning of cancer treatment, and this was probably the first of many transfusions this patient was going to require. So I just don't know legally, had the judge ruled in favor of treatment, then would there be a guardian who would have continued to maintain that, or would you have to go to court every time you needed treatment, or how does that work?
Actually, one of the techniques that they tell is for attorneys who are trying to represent Jehovah's Witnesses to make sure that it's only one treatment, one blood transfusion, so that you guys have to go back and get repeated court orders. That's kind of a legal strategy that's used. Probably they would assign a guardian ad litem. In the most recent case that I brought out from Wisconsin, she was transfused multiple times. She had a guardian ad litem that oversaw all of that. The Canadian case, BHV Alberta, she was transfused 38 times. The interesting thing there is when the mother was not in the room and she was being transfused, she was fine. The second the Jehovah's Witness attorney walked into the room and the mother walked in the room, she started fighting back. So finally, they just had the family not be in the room when she was being transfused. I wasn't able to put this information into my slide presentation, but that's because you're also told that if you don't physically fight and other Jehovah's Witnesses see that, they're supposed to basically turn you in, because not fighting is the same as acquiescence, and acquiescence is the same as acceptance, and acceptance is disfellowshipping. And so she was confused because, again, she was being told that she had to fight, and so if she didn't want to get in trouble, when Jehovah's Witnesses around, she was all pushing back. But when they weren't there, then she was just fine. And the Madam Justice Kent, I believe her name was, actually quoted that and spoke about how kind the hospital workers were. They were holding her and just comforting her when she was having her blood transfusions, and there was no problem with that. But normally what they would do is appoint a guardian ad litem who would oversee the whole series of transfusions.
Hi, thank you very much. As you guys were talking, I was really trying to think about what we do as clinicians and what we do as ethicists on a daily basis, depending kind of what hat we wear as clinicians. And I really liked your question about what is faith, but also realizing what is logic at the same time, realizing that as clinicians, I think we make decisions every day that are based on logic. And we have lots of families that make decisions for things that make sense, things that we understand, things that we don't understand. Sometimes things are for faith, sometimes things are without faith. And what I find really interesting is that we offer treatment or withhold treatment and information to families based on what we think is clinically appropriate at that specific time. But in this specific scenario, clearly there are many people that felt that this was appropriate. And we work with families that make logical or illogical decisions regardless of the reason, whether it be for faith-based reasons, non-faith-based reasons. We have the ability to intervene to help out those clinical scenarios. And it's in working with other faiths, faith is something that it's something that's inside. You can't reason through it, you can't logic through it, it's something that you have a belief to. And as physicians, it's not uncommon that you say, okay, this is what we think needs to be done to continue care for that patient or not continue care for that patient. And I really liked your comment where you said, within our faith, if I make that personal choice, it's upon me. It's between me and God, between me and my community. But some of our obligations as providers is we are the people that take away that thing in the name of saving life from the obligations that we've taken as healthcare providers. I think that's the intricacy of being a physician and the intricacy of being an ethicist, and part of a community member is understanding the intricacies of our different cultures and things that we're working with. I'm of the Jewish faith, and there's all sorts of interesting things at the end of life and beginning of life that we work with. Jehovah's Witnesses relating to blood, Catholicism, there's a whole other set of things. And as physicians, we have to work with and all the different religions, all these different faiths, and it's how do we interact with that. And I think in this scenario, exactly like you said, is sometimes it doesn't feel good to make those choices for our families, but it's what we feel is best for our obligations, not just for their faith's obligation.
Thank you very much. I'm going to get in trouble if I don't cut it off. I have lots of questions, though.